Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, we are going to understand a very important and often misunderstood legal issue. If a husband purchases a property in his wife's name, does the wife become the real owner? Or can the husband later claim it as his own? Let's understand the latest law and Supreme Court rulings on this topic. 1. What the law says. Benami Transactions Act. The key law governing this issue is the Benami Transactions Prohibition Act, 1988, which was comprehensively amended in 2016. As per this act, any property bought in someone else's name using your own money with the real intention of retaining control yourself is treated as a Benami transaction, which is illegal and punishable. However, there is an important exception under Section 2(9)(a)(3) of the Act. This section clearly states that if a person purchases property in the name of their spouse or child, and the payment is made from known and legal sources, the transaction is not Benami. So, if a husband buys a property and registers it in his wife's name using his declared and lawful income, the law presumes the wife to be the legal owner. 2. Presumption of gift intention is key. This exception is based on a long-recognized legal principle known as the presumption of advancement. In close family relationships, like that of a husband and wife, the law presumes that the transfer was made out of love, trust, and affection, and not for the purpose of hiding true ownership. This means, even if the money came from the husband, it will be presumed to be a gift to the wife, unless there is solid evidence proving that she was only a namelender. 3. Burden of proof lies on the alleging party. If someone, including the husband or his legal heirs, later claims that the wife was only a benamidar, the burden of proof lies entirely on the person making that allegation. Courts will not set aside the wife's name on the property unless there is clear, direct, and legally admissible evidence showing that the wife had no beneficial interest and the husband intended to retain ownership. 4. Landmark Supreme Court judgments. Several judgments have clarified this position. In Jayadal Poddar v. Bibi Hazra, 1974, 1 SCC 3, the Supreme Court laid down 6 factors to determine whether a transaction is Benami. 1. Who paid the purchase money? 2. Who is in possession of the property? 3. Nature of the relationship between the parties. 4. Who holds the title documents? 5. What was the motive for using another's name? 6. What was the conduct of the parties after the purchase? In Thakur Bhim Singh v. Thakur Kan Singh, 1980, 3 SCC 72, the court reaffirmed that in close relationships like that of husband and wife, there is a strong presumption of benefit or gift, not Benami. In Valyamal, D. by LRs v. Subramaniam, 2004, 7 SCC 233, the court ruled that intention and funding are crucial, and if the property is in the wife's name, she is presumed to be the owner, unless convincingly rebutted. Most recently, in Shaifali Gupta v. Vidya Devi Gupta, 2025 INSC 739, the Supreme Court held that whether a property is Benami or not is a mixed question of fact and law and cannot be decided summarily, it must be determined after a proper trial. 5. Hindu Succession Act Full Ownership of Wife. According to Section 14(1) of the Hindu Succession Act, 1956, any property possessed by a Hindu woman, whether acquired by gift or otherwise, becomes her absolute property. This reinforces her right to hold and manage such property independently. Therefore, once the property is registered in the wife's name and she is in possession, it becomes her personal and absolute property, not part of the husband's estate. 6. Taxation, divorce, and inheritance issues. Under the Income Tax Act, gifts between spouses are exempt from tax under Section 56(2). However, any income generated from such a gifted property may be clubbed back with the husband's income under Section 64(1)(4). In the case of divorce, the husband cannot claim the property as his unless he proves, with legal evidence, that the wife was only a benamidar. Similarly, in the case of the husband's death, the property does not form part of his estate and cannot be claimed by his legal heirs. 7. Final legal position, as of 2025. To conclude, If a husband purchases a property in his wife's name using his legal and declared funds, it is not a Benami transaction. The wife becomes the legal and beneficial owner of the property. This is protected by the Benami Transactions Act, upheld in multiple Supreme Court judgments, and reinforced by the Hindu Succession Act. Any contrary claim will require very strong and specific evidence and cannot be based on assumptions alone. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.